Dialogue, dialogue. That's, I think, the important thing, because if you share the problem, if you've lost your job, then your ex-spouse, however difficult he or she may be, has got to realise that we are in exceptional times.
And can you speak to each other without the use of mediation, and agree between you what financial changes you might agree to take over the next 3 months, say?
Yes, I think you do that, but I would suggest that you both, it's not legally binding, but that you both sign a stated intention.
What you can't do is just stop paying and think that your spouse, your ex-spouse, is not going to do anything about it. So the first thing you've got to do, if dialogue is not working, you've got to speak to a mediator to talk about whether mediation might be an option in this scenario. And under present law, you can't make an application to vary the terms of an order until you've at least discussed with a mediator whether mediation is viable. If it's not viable, or if you don't want to mediate, then you have to get a certificate from the mediator to enable you to make an application to the court, and therefore that should be done as soon as possible.
You can't say what you haven't got, so it's really difficult, because I think every case turns on its facts, doesn't it? Because everyone is different, and so it's very difficult to give generalized advice.
If you've heard that your spouse has lost their job, you'd want to contact them to see what could be achieved. So, for example, if the husband was paying spousal maintenance under a court order, you would want to ask him if he had received some kind of extra payment. If he was furloughed, was he getting 80% or was he getting 100%? And if he was getting 100%, why can't he continue paying the maintenance? Well, if it's likely to be long-term, so if you've been laid off per se, then the longer-term advice, as soon as they can get together the court fee and they go through the obligations with the mediator, is to put an application to vary. But the fact of the matter is, the variation application could take 6 months to 8 months to resolve.